The Supreme Court on Tuesday, in a landmark ruling, has struck down a law that denied maternity leave to adoptive mothers if the child was older than 3 months, holding that the restriction was arbitrary, discriminatory, and unconstitutional. Hello, this is Ruchi Bhattar, and in this video, we look at how one mother's public interest litigation led to a landmark Supreme Court ruling that struck down the 3 month age gap on maternity leave for adoptive mothers. Striking down Section 60, Clause 4 of the Social Security Code 2020, the court ruled that an adoptive mother should be entitled to a maternity leave of 12 weeks, notwithstanding the age of the adopted child. It started with an adoptive mother of two, Hamsa Nandini Nanduri, who had challenged Section 60, Clause 4 of the 2020 Code, erstwhile Section 5, Clause 4 of the Maternity Benefit Act, which entitles only those mothers who legally adopt a child below the age of 3 months or a commissioning mother to seek maternity benefit for a period of 12 weeks, stating that it creates an unreasonable classification among adoptive mothers. Through a public interest litigation, she argued in court that the provision overlooks the physical and emotional well being of the adoptive child aged 3 months or above, as well as the adoptive parent. Thus, the provision, she told the court, is arbitrary, unreasonable, and discriminatory not only towards the mother but also towards the child. Plus, the petitioner highlighted that this section restricts a woman's right to carry on her trade, occupation, and business guaranteed under Article 19(1)(g) of the Constitution based on the child's age. She added that such a restriction dissuades women who are working professionals from adopting. A bench of Justices J.B. Pardiwala and R. Mahadevan on Tuesday held that there isn't any difference between a biological and adopted child for a family, although biology has traditionally been the predominant lens through kinship. Adoption is an equally valid pathway, concluding that biological factors by themselves do not determine family, and adopted child is not different from a natural child. The approach adopted by the legislature while enacting the provision, the court said, does not reflect the real world requirement of care and nurturing, which does not come to a sudden halt upon the attainment of a certain mathematical number, but gradually tapers with the proper integration of the child with the new environment, especially the parents. Section 60, Clause 4 of the 2020 Code, it said, operates unequally upon adoptive mothers who are similarly situated, resulting in discrimination without reasonable justification. As a necessary consequence, the Code violates the mandate of equality enshrined under Article 14 of the Constitution, the top court of India held. It said, and I quote, that the classification under the Act is palpably unreasonable and arbitrary, end quote. Section 60, Clause 4 of the 2020 Code is discriminatory, the court held, because first, it does not disclose a reasonable distinction between women who adopt a child below the age of 3 months and those who adopt a child aged 3 months or above. Secondly, the particular differentiation which is sought to be made has no nexus with the object sought to be achieved. And third, the court held that the classification suffers from an under-inclusiveness. Getting deeper in everyday life, the absence of an age limit assumes greater importance when we consider the position of children with disabilities, the court said, noting that children with disabilities often wait considerably longer to be adopted as compared to other children. The process of identifying adoptive parents, ensuring that they are capable of providing the required care, and completing necessary formalities would ordinarily take longer. Thus, the court said that in such circumstances, in the absence of any parental leave, maternity benefit leave enables the adoptive mothers to devote adequate time towards nurturing, rehabilitation, and emotional bonding with the child. Plus, this issue assumes a distinct dimension in the case of single adoptive mothers, the bench noted. Unlike in a traditional family setup where caregiving responsibilities may be shared between two parents, a single adoptive mother bears the entire responsibility of integrating the child into the family environment while simultaneously discharging her professional obligations. More so, in the absence of adequate maternity benefit, a single adoptive mother may be compelled to choose between her employment and the immediate needs of the adopted child. Such a predicament undermines the very purpose of a social welfare legislation designed to support working women, the court held. It also noted that the components of maternity leave broadly consist of three elements. First, the time necessary for physical recovery following childbirth. Second, the time required to nurture and develop the emotional bond between the mother and the child. And third, the time necessary to attend the physical and emotional needs of the child and to facilitate the process by which the child gradually integrates into the family, with the mother often acting as a primary medium through which the child is introduced to the familiar environment. However, it distinguished how, in case of biological birth, these three aren't largely distinguished from. In case of adoption or surrogacy, it held that the first component is absent and the second and the third are present and significant. When the family structures and modes of parenthood have evolved and diversified, it said that parenthood is not confined to the biological act of giving birth. It includes a broader spectrum of choices through which individuals realize their aspiration to build a family, thus stating that an atypical or unconventional familial setup does not strip away the rights guaranteed by the Constitution. An overarching theme that the court saw in precedents across the globe was that the best interest of the child must remain paramount consideration in all decisions affecting a child. On this, the best interest of the child does not conclude with the completion of the formalities of adoption or handing over the custody of the child to the adoptive parents. It also noted that the true fulfillment of the child's welfare lies in enabling the child to meaningfully adjust, bond, and flourish within the family environment. Practical difficulties in this context, the court said, is by the time the child is declared legally free for adoption, it is likely to remain within the narrow age threshold of 3 months contemplated by the provision. The inevitable consequence is that although the statute ostensibly confers maternity benefit upon adoptive mothers, yet the benefit remains largely inaccessible in practice. At the same time, urging the union government to come up with a provision recognizing paternity leave as a social security benefit, the Supreme Court of India deeply emphasized on the need for a legislation. The current law grants a male government servant 15 days of paternity leave for the birth of a child or for adoption, which the court said shows the concept of it is not alien but actually less recognized. Highlighting the duration of such leave must be determined in a manner that is responsive to the needs of both the parent and the child. The court said that parenthood is not a solitary function performed by one parent, but rather a shared responsibility in which each parent contributes to the child's holistic development. Showing two consequences of absence of paternity leave, the court said it reinforces gender roles in parenting, and even where a father is willing and desirous of contributing, he is left without a meaningful opportunity to do so. With that, thank you for watching.